Hello friends, today we're going to discuss about advertisement and doctors. I am Dr. Suresh Padadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about whether a doctor should involve in advertisement, what is the definition of advertisement, invent of social media and internet, how this advertisement is eroding the ethical and legal issues with regard to medical practice, what are the international guidelines with regard to advertisement by doctors, what does the MCA regulation says about this, NMC regulation, and my personal recommendation with regard to advertisement by doctors. Let's define advertisements. Advertisement means, as per the Black Law Dictionary, it clearly says notice given in a manner designed to attract public attention, information communicated to the public or to an individual concerned by means of handbills or the newspaper. This is the old definition. But the invent of internet, social media, web pages, now the advertisement has become rampant in virtual world. Hence that definition is although good for the physical world but not in the virtual world. Now let's look at the definition by Lexis and Nexus. As per them, advertising is defined very broadly to encompass any form of representation that is made in connection with business in order to promote the supply or transfer of a product. Here, it's very clear. It says very broadly, which encompasses any form of representation. That means it can be virtual or else it can be even in the physical world. That means offline, online, any kind of representation can be considered as advertisement, and it is a broader definition. Now, what are the reasons for advertisements? The registered medical practitioner, that is doctor, would like to attract or lure patients so that he can make money. Further, he also wants to promote his expertise, telling that I've learned new things, I can do good procedure, and I am available here. He also wants to build a brand, maybe his name, maybe his hospital. So in various form, he wants to promote himself. Many a time, even doctor also would like to endorse a product, device, maybe even medications. Further, he also wants to become popular or famous. Some of the doctor would like to do advertisement in the form of educating public with regard to certain illness and also how to take precautions to prevent such illness. Further, he also wants to do these advertisements to inform regarding the newer technology, about what are the costs involved in this technological treatment, and also if he is going to start a new services or he is going to offer some newer technological treatment. And further, he wants to be competitive in the marketplace so that he can get more revenue. That means advertisement is invariably leads to generation of more funds. Now let's look into the ethics. What does the medical ethics talks about advertisement? If you look at ethics in advertising refers to the moral principle and the standards that govern the conduct of doctor involved in advertising and their communication with their patients. That means the ethics is how he is communicating, why he is communicating, what he is communicating, whether he is going to betray the patient or give false information or mislead the patient, or he wants to do these advertisements or providing information for the benefit of the patient. That means it is the moral principles and the standards on which this advertisement stand. If you look at the medical ethics with regard to autonomy, suppose if you are doing advertisement, invariably, you are going to exaggerate your skills. You may provide misleading information so that you can lure the patient and you get more financial benefit. That means you are coercing the patient to choose you. That means you are manipulating their decision by not giving the right information. Again, advertisement means the beneficiency is towards the physician, not to the patient. That means even the second important ethics is also violated. Non-maleficency. Advertisement and aggressive advertisement will harm the patient financially. Further, during this advertisement, many a time the doctors cross their boundaries and start discussing about the patients whom they have seen. Confidentiality of the patients are thrown into the dustbin. Patients' photographs, patients' images are shown in public or in social media. Further, by doing advertisement, you are also violating the justice. That means equitable distribution of the resources will be hampered. The patients who are able to pay will approach you. That means the basic premise of the medical ethics is broken. Further, the more you do advertisement, the professional integrity and boundary starts becoming blurred. Invariably, you are more becoming financially targeting, and the clients become the way of making money. So, the doctor advertisement, if they are doing, it has to be truthful, benefiting the patient. The doctor should be honest, non discriminatory, and not misleading the patient. That means if you are doing anything in the benefit of the patients, not to the doctor, may be considered. This is what the international community of doctors speak about. Now let's look at the various issues around the advertisements. Invariably, all professionals, it may be lawyer, it may be engineer, it may be chartered accountant, including doctors. Invariably, all these professional associations ban advertisements by these professionals. That means even in doctors, they cannot do advertisement. But the corporate hospitals, nursing homes, polyclinic, private medical colleges, private labs, they do advertisements. In these advertisements, invariably, doctor's name, photograph are utilized to lure the patient to their clinic or lab. That means the doctor cannot do the advertisement, but the hospitals can do. Many a time, these hospitals will do advertisement by giving false information, misleading the patient, taking advantage of the vulnerable patients. They make huge amount of money. Further, these online social media platform advertisement is becoming rampant. Further, professional associations, professionals, they are also getting involved in endorsing various products. That means a physician association may say, you can use this product and it is certified by this physician without having any research doing on the project or maybe the product. Further, during these advertisements, patients' photographs are posted on the social media. And many of these doctors go one step ahead. They pay money to alter these algorithms so that whenever there is a search done, this doctor's name comes first. That means they are manipulating to get the patients so that revenue increases and they become very famous. Now let's understand the legal definition of advertisement. At present, the legal definition of advertisement is neither given by MCI or by the NMC. That means the medical laws are silent about the advertisement, especially the NMC and MCI. Now the question also arises, advertisement, is it only in the physical space, or else even in the virtual world is it considered? That is formal press and informal press. Whether the advertisement in both the domains, is it considered equally or different? Now let's look into the important legislation, that is the Drugs and Magic Remedies Act of 1954. This is objectionable advertisement. Here in this legislation, which was given in 1954, section 2A talks about advertisement. Here it says advertisement has been defined, which includes any notice, circular, label, wrapper, or other document, and any announcement made orally or by any means of producing or transmitting light, sound, or smoke. Invariably, this definition was given in 1954. That means that time there was no internet, social media. Hence, it revolves around physical area only or physical advertisement. Further, this legislation also prohibits advertisement under Section 4. This Section 4 clearly says prohibition of misleading advertisements relating to drugs. That is, directly or indirectly, if the doctor is involved or any other person is involved, giving false impression or make a false claim for the drug or misleading in any material particular, that will be considered as misleading advertisements. Section 5 clearly says prohibition of advertisement of magic remedies. Here, for the treatment of certain diseases such as conception, sexual pleasure, menstrual disorder, and other notified disorders. If there is any claim is done, then it comes under Section 5 and the prohibition is there. If you violate any of these, the penalty under Section 7 clearly says that the first conviction will be for 6 months or with fine or both. If he continues to do advertisement, then the imprisonment is either 1 year or with fine or both can be considered. Now let's look into the Consumer Protection Act 2019, which was recently notified. Again, here under Section 2(1), the definition of advertisement has been given under the Consumer Protection Act. Let's look into that. Advertisement means any audio or visual publicity, representation, endorsement, or pronouncement made by means of light, sound, smoke, gas, print, electronic media, internet, or website, and includes any notice, circular, label, wrapper, invoice, or any other such documents. That means this is a comprehensive definition of advertisement. This Consumer Protection Act of 2019 also defines endorsement under Section 2(18). It means endorsement under relating to advertisement means any message, verbal statement or demonstration, or depiction of name, signature, likeness, or other identifiable personal characteristic of an individual, or depiction of the name or seal of an institution or an organization which makes the consumer to believe that it reflects the opinion, findings, and experience of the person making such an endorsement. That means not only advertisement, endorsement also is considered under the Consumer Protection Act. It is maybe messages, it may be verbal statement or demonstration. And by name or using signature, the doctor is telling, I like this product. That means you are giving a false information, opinion, findings about the product. Further, the same Consumer Protection Act under Section 89 discusses about misleading and false advertisements. Here it says any manufacturer or service provider who cause a false or misleading advertisement shall be punished with an imprisonment for a term which may extend to 2 years and with a fine which may extend up to 10 years of rupees. That means it is very severe here. The imprisonment of 2 years and up to 10 lakh rupees punishment can be given for every subsequent. That means he's already punished once and he continues to do advertisement. In such a case, the doctor will be punished with an imprisonment of a term which may extend up to 5 years and with fine which may extend up to 50 lakh rupees, my dear friends. If you move to Clinical Establishment Act of 2010, and this, though a central act, many of the union territories and some of the states have notified this Establishment Act, health being the state subject. This Clinical Establishment Act can be modified and adopted, such as in Karnataka. In Karnataka, it is considered as private Clinical Establishment Act. That means it is not applicable to the government. Similarly, West Bengal has come up with their own Clinical Establishment Act, which has modified the center. Here again, this Clinical Establishment Act, which is applicable to the hospitals, labs, here they are silent about advertisement. However, this legislation also mandates every clinical establishment to display the registration certificate, the doctor's fees, cost of lab services, and other services within the premises of the hospital. That means there is a mandate to be transparent. However, this legislation does not prohibit these corporate hospitals to publicize or do any advertisement. This is with regard to Indian laws. Now let's look into the international norms with regard to advertisement by the registered medical practitioner. If you look at the World Medical Association International Code of Medical Ethics with regard to advertisement, under Code 24, it says the physician must refrain from intrusive or otherwise inappropriate advertising and marketing, and ensures that all information used by the physician in advertising and marketing is factual and not misleading. That means World Medical Association has not banned it, not prohibited it, but it says the doctor should provide factual information and it should not be misleading. If you look at the policy on advertisement by American Medical Association, what does it say? It says a physician may publicize provided that the communication shall not be misleading because of the omission of certain necessary material information, shall not contain any false misleading statement, or shall not otherwise operate to deceive. That means it is very clear. Here, the doctor will not mislead the information, or else he will not omit certain important information. Suppose the doctor may say you can use this medicine, but he does not tell about the side effect. That means he's omitting certain important information. Further, it says he needs to give factual information to the patient, and he should not do any misleading activity so that the patient's decision is not coerced or altered. Similarly, General Medical Council of UK, with regard to the advertisement, it talks about communicating information. The Code 70 says when advertising your services, that is specifically to the doctors who are in private practice, you must make sure that the information you publish is factual and can be checked and does not exploit patients' vulnerability or lack of medical knowledge. That means here also it is very clear. They have not prohibited, but they have said it has to be factual, to be checked and verified, and should not exploit the patient. Similarly, Canadian Medical Association, this does not have any specific guidelines on advertising by the physician. Now let's look into the Indian Medical Code and how these regulations play a role. If you look at the Indian Medical Council, Professional Conduct, Etiquettes and Ethics of Regulation 2002, amended in 2016, let's look into that. In this 2002 Ethics and Regulation, 6.1.1 talks about soliciting of patient directly or indirectly by a physician or by a group of physicians or by an institution or an organization is considered unethical. Although this looks very interesting, but the MCI regulation is applicable only to the doctors. It is very difficult to apply this on the institutions, to the medical colleges, corporate hospitals, and polyclinic, because they say we are not doctors. However, indirectly, you can influence the doctor by telling any of the hospitals or organization, if they are doing any advertisement, the doctors will be prohibited working there. That means 2002 regulation is very clear. Neither direct or indirect, neither the doctor nor the corporate hospital can do advertisement. Further, a physician shall not make use of his name or her name as a subject of any form or manner of advertising or publicly through any mode, either alone or in conjunction with others, which is of such a character as to invite attention to him or to his professional position, skills, qualification, achievements, attainments, specialities, appointments, association, affiliation, honor, or such character as would ordinarily results in aggrandizement. That means you are not supposed to do any advertisement. Further, it also says, a physician shall not give to any person, whether for compensation or otherwise, any approval or recommendation, endorsement, certificate, report or statement with respect to any drug, medicine, remedy, surgical devices, therapeutic articles, operators, appliances, commercial product or article with respect of any property, quality or use thereof, any test, demonstration, trial thereof for use in connection with his name, signature, photograph, in any form of advertisement through any mode, nor shall be boast of the cases, operations, cures, remedies, or permit the publication of report thereof through any mode. That means it clearly says the doctor is not supposed to do any kind of advertisement. However, 2002 allows the medical practitioner to give information in press with regard to starting of a practice, or if he is going to change of type of practice. That means he was earlier just an MBBS, now he has done MS surgery and he is restarting his practice after doing surgery. Then he can publicize telling that I am available in this place, have now done MSc and I am a surgeon. Any change of address, a temporary absence from the duty, suppose the doctor is going somewhere abroad for a period of 1 to 2 months, he can publicize in the newspaper telling that he is not available. Any resumption of another practice, on succeeding of another practice, or public declaration of his charges. Under this pretext, the doctor is providing advertisement to give information to the patient. Further, 6.1.2, here it says printing of self-photograph or any such material of publicly in the letterhead or on signboard of the consulting room or any such clinical establishment shall be regarded as act of self-advertisement and unethical conduct on the part of physician. However, printing of skeletons, diagrams, picture of human shall not be treated unethical for the purpose of educating the public at large. This is regarding MCI ethics regulation, which was there in 2002, amended in 2016. Now let's look into the National Medical Commission's Registered Medical Practitioners Professional Conduct Regulation 2023. If you look at this regulation, there are 5 chapters and 11 guidelines. Here, with regard to advertisement, I'll be now considering discussion of professional conduct of RMPs, that is from Regulation 2 to 21. Now let's look into this. Here, it clearly, under the Regulation 7, it says prohibiting soliciting of patients. That means RMP shall not solicit patient either directly or indirectly, or as a part of a group of RMP or an institution or an organization or hospitals or nursing homes or corporate hospitals endorsed or owned, controlled or maintained by the appropriate government, local authority, trust, whether a private or public, cooperative societies, organization or any other entity. The advertisement is not allowed. If the doctor is involved in such advertisement, the punishment is L2. That is, 30 days of suspension of his license. Suppose if the doctor is involved in fee splitting or giving commission, RMP shall not directly or indirectly participate in act of division, transfer of assignment, subordination, rebating, splitting, discount, refunding of any fee of for diagnostic scanning, medical, surgical or other treatment. RMP shall not use online forums or agents to procure patient. If he does this, L3, that is 3 months suspension of his license to practice. If you look at the regulation 10, prohibition of endorsement of the product or a person. If an RMP, individually or a part of an organization, association, society, shall not give to any person or any companies or any product or to any software or platform for whether for compensation or otherwise advertising them. That means again the punishment is L3, that is 3-month suspension of his license to practice. However, similar to MCI regulations, here NMC regulations talks about RMP is permitted to make formal announcement in any media, either it may be print, electronic or social, within 3 months regarding the following: on start of practice, change of type of practice, changing the address, temporary absence from the duty, resumption of practice, or succeeding to another practice, public declaration of charges. If any of these violation is there, it is L2, that is 30 days of loss of license to practice. Further, RMP or any other person, including the corporate hospital, running a maternity home, nursing home, private hospital, rehabilitation centers, or any other medical training institution, may place announcement in the print, electronic, or social media, but these should not contain anything more than the name of the institution, type of the services provided, what type of patients admitted and treated, kind of doctors and staff, training and other facilities offered. That means they are not going to violate the ethics or regulations with regard to publicizing other information. Here the punishment is L1 and or L2. That means warning or 30 days loss of license to practice. RMP is not allowed to do any, but again, here RMP is allowed to do any public education through media without soliciting patients for himself or the institution. That's what I'm doing here. That is, I'm educating the public. I'm not here to solicit any patients. I'm working for the government institution and I don't do any private practice. My job is to educate the patients, the professionals, and also paraclinical professionals. If anybody violates this kind of advertisement and through education you're soliciting patients, that means the punishment is L2, that is 30 days of loss of license to practice. If you look at the chapter 4, it talks about duties of RMPs towards the public and allied healthcare professionals. Here, it says RMP as a good citizen have a responsibility to disseminate scientific advice on public health issues in the public interest without self-promotion. Here, if he does self-promotion, the warning can be given. For example, in COVID, the doctors had responsibility to provide recent scientific informations which are available across the globe and help the patient to make appropriate choice. With regard to public education and awareness, RMP should enlighten the public concerning quarantine regulations and measures of prevention of epidemic and communicable diseases. At all the time, the RMP should notify the constituted public health authorities of every case of notable diseases under this care, following the laws, rules, regulations of the health authorities. RMP need to involve in public education and awareness activities without involving in the advertisement. When an epidemic occurs, RMP provides with all necessary medical protection, should not abandon his duty for fear of contracting the disease. That means this ethics also is very clear. If you provide good protection to the doctor, he is not supposed to abandon the medical duty. As you know, during COVID, when there were no protection gears, the doctor refused to work. That means he's allowed to do that. If they provide adequate PPE kits, protectional measures, he should provide care to the patients. If he violates this, the punishment is level 1 or level 2. That means warning or 30 days of loss of license to practice. Now, if you look at the important one is conduct of RMP on social media. I made a separate video on this with regard to RMP's roles and responsibility on social media. Here, RMP can provide information and announcement on social media, but is not providing misleading information or advertisement. RMP should avoid discussing about the treatment of a patient on public social media or prescribing medicine to the patient on the public social media platform is prohibited. RMP should not post patients' photographs, scanned images on social media. RMP should not directly or indirectly indulge in the practice of purchasing likes, followers, or paying money to alter the algorithms of the search engines so that any search leads to his name so that he can increase his revenue. And if such kind of manipulations for soliciting patient is prohibited. RMP should not request the patient to give testimonials or recommendations, endorsement, or review on social media. RMP should refrain from sharing images of the cured or healed patients or surgical procedures, of videos, images, and displaying impressive results is prohibited. RMP is allowed to share educative materials for the information of general public. However, communication should be limited to the expertise of the RMP. RMP's web page should be in a format which will be dictated by the NMC. On social media, RMP should refrain from boundary crossing or violation and conduct themselves with a dignity and decorum. Soliciting of patient directly or indirectly on social media is prohibited. At the same time, if you look at the guideline 11, that is telemedicine practice guideline, which was notified in 2020, what does it say? Under this TPG guidelines, 3.5, RMPs are not permitted to solicit patient for telemedicine practice through advertisement or inducement. That means even if you are doing telemedicine practice, you are not supposed to do any advertisement. Further, 5.2, RMP shall not participate in telemedicine platform that provide rating by the patient or other including reviews, advertisements, or promotion of RMPs in any mean. That is, manipulation of algorithms and search engines. At the same time, if these platform says rate the doctor is not allowed, and if it is considered the doctors are prohibited in providing services on such platform, advertising of RMPs is not allowed by anybody under any pretext. The code number 5.4 says the platform must provide the name, qualification, graduation, post-graduation, specialty, any special training, registration number, contact details of every RMP listed on the platform. That means telemedicine practice guideline casts an obligation on these software or platforms which claim to provide services through the RMPs. Now let's look into the current Supreme Court, the case which is pending. Narayan Aniruddha Malpani versus NMC, a PIL was filed in 2023. Dr. Anirudh Malpani clearly said that here, arguing that unethical advertisementing by corporate hospital contradicts the Medical Council regulation which was given in 2002, which prohibits solicitation of patients directly or indirectly by using medical practitioner is unethical. However, he asked the court, there are many corporate hospitals, private medical colleges, labs are doing advertisements using doctors, nurses, their photographs, live videos. And he said, if you are allowing the hospitals to do, and doctors are not allowed to do advertisement. That means over a period of time, corporate hospitals will win, and the individual doctors and the doctors which are doing polyclinic, they are going to lose because they are not doing an advertisement. That means there should be equal footing between the doctors who are practicing and the corporate hospital. Either you ban both or allow both. That was his petition. Still, this petition is pending in the court of law. Now let's look into the recommendations, which I personally feel and I believe they should be there. If you look at the NMC, it has taken certain midway. Neither they are completely prohibited the advertisement, or else they have not given a free run to the doctor to do any kind of advertisement. NMC, in its recent regulation which was published, but however it is kept in abeyance, has encouraged publicizing the services and also has mentioned not to take an undue advantage of the patient's vulnerable position by providing false advertisement and misleading advertisement. They talk about ethical advertisement so that the patient is educated, empowered, so that he makes a proper decision. To conclude, all developing countries have not prohibited advertisement, but however, they have placed certain regulations, obligations on the doctor to provide factual information, not to mislead the patient. And if they mislead the patient or manipulate the patient's decision by giving wrong information or omitting certain important information, that will be considered as unethical conduct. Further, the Consumer Protection Act of 2019 gives a very good punishment or penalty to the doctors or any other person who are providing misleading advertisements or providing false advertisements. Further, online and social media advertisement has opened a new challenge with regard to soliciting of patient directly or indirectly. No patient should be misled through advertisement is a very clear, either in the ethics or else in those countries where the services of the doctors can be advertised. Medical ethics at any cost should be upheld, and the benefit of the patient should be the prime. Under no circumstances, patient should be taken advantage of their vulnerable position. Hence, before NMC or any other association would like to allow the doctors to do advertisement, there should be adequate checks and balances so that neither the corporate hospital nor an individual doctor or a group of doctors take advantage of these patients. So, finally, my personal opinion is doctor should not be allowed to do the advertisement. At the same time, even the corporate hospital should not be allowed to do any kind of advertisement. That means both hospitals and doctors should not indulge in any way of advertisement, either directly or indirectly, either online or offline, should be prohibited so that the medical ethics is upheld. Thank you very much for giving your valuable time. Stay safe.